So without further ado, I have the honor of introducing our moderator, Shannon Hilding. She is our Director of Property and Casualty here at the Miller Group, and she has 10 years of experience in insurance, and she also has a background in law and compliance. Shannon specializes in liability subject matters and placing insurance coverage for our construction clients. So Shannon, you have control.
Thanks, Amanda. Welcome, everyone. Thank you for joining our discussion today on a topic that can cause significant tension in the workplace, workers' compensation, and the difficult employee. We have assembled a panel today to discuss proactive management of problematic employees, employer issues and solutions, as well as provide some insight on return to work programs. Before we get started, I do need to share a legal disclaimer, which is that this webinar is not intended to serve as legal advice for individual fact-specific legal cases or as a legal basis for your employment practices. We always advise that you speak with an attorney prior to implementing any policies or procedures within your company. Let me introduce our panelists to you today. Please meet Attorney Mitchell Wood with Halbrook Wood Law. Mitch has extensive experience in workers' compensation law, defending businesses in various practice areas, and has successfully tried cases in federal and state courts in Missouri and Kansas. In addition to litigation, he advises clients on issues related to workers' compensation and provides corporate training on for both for-profit and nonprofit organizations. I'd also like to introduce you to Aaron Paris. He's the Director of Safety here at the Miller Group. He has more than 6 years of experience in workplace safety, 12 years of law enforcement experience. He works closely with our clients here on a wide variety of safety issues, such as worker safety, strategies to reduce injuries, and other safety procedures. So let's get started on our discussion today. We're going to start with a poll, which should pop up here in just a moment on your screens. And the question is, have you ever had to discipline an employee with an open workers' compensation claim? So give us a vote now and let us know. Looks like it's coming in. Okay, so it looks like, well, largely no. So it sounds like luckily few of you have experienced the situation, which is great. So thanks for that feedback. Let's jump into it. We're going to turn to Mitch first, and let's talk about a situation where you have a difficult employee who sustains a workplace injury. So Mitch, let's say you have an employee who is not meeting job performance standards, and then they get hurt on the job. How difficult is it to terminate an employee after they've filed a workers' compensation claim?
All right. Thanks, Shannon. And thank you all for attending this. Happy to talk to you all about this. So as Shannon mentioned, I do work comp and employment defense, which means I advise businesses, represent businesses in a variety of employment issues, which means I kind of get to see the worst sometimes in employees, sometimes in employers, but you know, in employees. And get to see all kinds of crazy situations that you couldn't even make up. And the reason why I think it's important that we're having this discussion today is because there's a very common aspect to work comp, which is a claim of work comp retaliation. And so kind of to answer Shannon's first question, I really wanted to talk about that. And first, I want to make sure everyone kind of understands what work comp retaliation is. It is separate from a workers' compensation claim. So a workers' compensation claim is going to be administrative. It's going to be, you know, the employee was injured on the job. There may be a dispute about, you know, whether they were actually injured, the extent of the injury, things like that. An administrative law judge would make a decision. But the work comp retaliation claim is actually a separate civil claim that's going to be filed in civil court. And if anyone's ever been through this at work before, you may even have separate attorneys. One attorney will handle the work comp claim itself. The other would handle a work comp retaliation claim. But they are different. And I want to just point out what work comp retaliation is, because I think having that mindset will really help the way that you handle an employee with a work comp injury, especially if you have to discipline them. And let's start with the basic elements of it. And we're going to be focusing on Missouri and Kansas law today. I recognize that some folks may be from other states, and that's fine. But for purposes today, we'll look mostly at Missouri and Kansas. And it's a little different even in those two states, but the gist of it is, number one, the employee attempts to assert some kind of right under the work comp laws. And what I mean by that is it doesn't mean that he has to, he or she files an actual work comp claim. They can simply be reporting an injury. They can just be seeking treatment. They can be asking for light duty. Kansas even says if they might assert a future claim for an injury. So basically, if they do anything to try to exercise their rights under the work comp law, that's going to trigger the first element of work comp retaliation. So the second element is that the employer takes some kind of adverse action against the employee. Most often that is termination. You terminate an employee, and that employee has a work comp claim or tries to use their rights, and they're claiming it's because of that. But it doesn't have to be termination. It can be anything. It can be demotion. It can be, refusal to honor restrictions. It can be basically any treating that person different than any other employee. So that's also a broad category. And then the third element of work comp retaliation is that the termination or the adverse action is because of that employee's exercise of rights. There has to be a connection to it. Missouri says motivating factor. Kansas says causal connection. But basically, you just have to connect those first two elements. And so why are we talking about this? Well, the main reason is because if it's not handled correctly, if you've got an employee with a discipline problem who has some variation of a work comp injury, claim, report, whatever, a work comp retaliation claim can result in significant damages. Damages available under a claim of work comp retaliation include compensatory damages. So, like, for example, if you terminate the employee, they can claim their lost wages. They can claim, potential front pay, future pay that they would have made if they kept working there. They can claim damages for pain and suffering, emotional distress, and then punitive damages are available as well. And there's actually several examples of verdicts, even recently in Missouri and Kansas, that have resulted in several thousands of dollars on claims of work comp retaliation. And this is a claim that we see very often. And I think plaintiffs' attorneys are very eager to file this. And I think the reason why is because juries, and these are typically going to be decided by a jury, by the way, juries are very sensitive or sympathetic to people that have claims based on the fact that they were injured at work. And the reason for that is because I think juries think, well, if they were injured at work, it's probably not that person's fault. And so therefore, if their employer terminated them or did anything wrong to them, they're not going to like that. So that's why you see these claims quite a bit. And so a couple of other things to point out on that, it doesn't have to be a valid work comp claim to trigger work comp retaliation. If the employee makes a claim and it turns out that claim was denied, but the employer still does something adverse to them because of it, that can still be work comp retaliation because, again, it's really just their exercise of the rights under law. And then, I also like to point out to folks too, it just because of that, it doesn't mean that if an employee has, for example, a pending work comp claim or workplace injury, it doesn't mean they get to do whatever they want. Now, a lot of times, I've had examples of cases where the employee thought that. Kind of one that pops in my head is I represented a distributor. They had truck drivers. These drivers delivered truckloads of product to kind of bigger warehouses, and sometimes they had to kind of wait in line with other trucks to drop off their loads. And so one of the managers caught wind of the fact that one of the truck drivers would kind of park off to the side, let all the other trucks go first. He would take a nap in his truck, and then he would come in at the end and drop off the load. And so he, went out there, caught the employee doing that. After he finished his load, he told the employee, hey, when you get done with all your loads today, come back to my office and let's talk. So the employee knows, okay, I've screwed up. He caught me. I'm going to get fired. And I'm not making this up, he actually paid another employee to run over his foot with a forklift so he could get a work comp injury. So employees are definitely wise to the fact that, hey, if I'm on work comp, their belief is I can't be terminated. And while it always is very, if an employee is has an active work comp claim, you want to make sure you think about that. It doesn't mean that they can do whatever they want. So we'll get into this with the next subtopic, but the key is to make sure you document everything very clearly, because a lot of times any performance problems that you're going to deal with probably started before the work comp injury. So you just want to make sure you have sufficient documentation when you need to enforce that after there's been an injury.
Perfect transition. Thanks for that. I was about to ask you, what are best practices for documenting employee performance to protect yourself from a retaliation suit?
So you're going to get tired of hearing me say a couple things today, and one is documentation. It's just very important in these scenarios, and the other is have a relationship with employment counsel, and make sure you consult them, and when to consult them, and kind of when to make your own call, because inevitably what happens is you'll have a situation pop up and you really need to know something right then. So, again, make sure you have good employment counsel that you can rely on. And hey, I'm happy to do. That's what we do. Well, my information will be in the email that comes out, but I'm certainly not the only one. And if you've got relationships with employees or attorneys, make sure you do that. But there's just constant updates in the law that they're going to be aware of to be able to tell you about. But for purposes of kind of what you can take away for today, obviously, some of the stuff is going to sound very basic, but believe it or not, at least by the time it gets to me, this hasn't been done. So one is just to follow your own policies. I'm assuming most of you have handbooks and policies for discipline, for how to handle work comp claims, things like that. Make sure those are followed. For example, if you have a progressive discipline policy that says, violation 1, we're going to do this. Violation 2, we're going to do this. Violation 3 is termination. Follow that. Now, I know most of those have kind of an exception that says, we reserve the right to change that. And that's fine. You just want to make sure you're applying those things consistently. And so the main scenario that I'm talking about here, if you find yourself in, is, hey, I've got an employee that's either got a workplace injury or they've got an active work comp claim. And it was sometime close in time. It wasn't 2 years ago. It was either, last week, 6 months ago, whatever, sometime close in time to now. And this employee is a problem employee. They've been doing something. What do I do? And so that's when, in those situations, you want to make sure you are going off of your policies, because in the event that it is something where the employee ends up filing a claim and you have to defend yourself, you just want to be able to make sure that you have the tools you need to explain to a jury, this is why we did this. So documentation is going to be huge, because juries, they really focus on people and they focus on paper, and paper is kind of irrelevant now, but documentation is what I mean by that. If they believe the person saying it, and if they have a document, the juries are going to latch onto that. Another thing to make sure your business is doing is, even if you have good policies, even if you have good documentation, make sure your managers are following those things. Because a lot of times, maybe the folks that are on this webinar are not necessarily the frontline folks that are having to discipline employees or whatever. Those are other managers, shift leaders, whatever. Make sure those managers kind of know how to handle these things, because that's what I see very often in cases, is there's a breakdown in communication between kind of upper management or executive level policies, HR, and then what actually gets enforced down on the floor. So make sure managers are aware of policies and have somewhat regular training on those things. Another thing too that goes back to documentation is performance reviews. And this also is something that you want to make sure your managers are aware of. It may be that it's great if you have write-ups that lead up to a situation where you've got to terminate somebody. But sometimes you see a situation where, employees are given performance reviews every year. And I kid you not, I've had, cases where there's been just horrible conduct that the employee got fired for, and then you get their reviews, and every year it's like a copy and paste. It's all glowing. It's like, oh, he's excellent. We can't live without him. All these things. And plaintiffs' attorneys are very savvy, and they attack on those things, even if you have write-ups that led up to the termination, because what they're going to say is, well, hey, you just started papering the file so you can get rid of them. But if we look back to his last 3 reviews, this guy, he was a great employee. So just make sure that you're doing honest performance reviews, even though that is hard to do sometimes. Everybody's busy and nobody likes giving bad news, because that sometimes can come up in this situation. Specific to after the employee, if the employee is once the employee is injured and now you find yourself having to issue some kind of discipline, just a couple things to remember there. Number one, it doesn't affect disciplining employee or terminating employee. It does not affect the work comp claim itself. If they've got an active work comp claim, even if the employee is terminated, that doesn't go away. You will still deal with that until that work comp claim is resolved. And in fact, a lot of times, by the time a work comp claim is resolved, either the employee is quit, laid off, or terminated, or whatever. So just keep that in mind. And then if the performance issue that you are disciplining the employee for is not related to the injury or the work comp claim, do not bring that up. Do not make that part of it. And that sounds obvious, but I have situations, and you can probably imagine the scenario. You've got a problem employee anyway, and now they're injured, and maybe the injury is some kind of suspicious circumstance, and the employer is just really on alert, like, wow, this employee was already bad, and they were already taking up a lot of time. And now they've made this work comp claim, and I really don't think this happened. And so you just have this general idea in your head of like, this employee is up to no good. And so that will sometimes come up in a disciplinary meeting. But if it's not related to the injury, obviously don't bring that up. Now, if they bring it up, if they say, hey, this is because you're writing me up, you're firing me, this is because I was injured, or I have a work comp claim, or I've got restrictions, or I'm on light duty, or whatever, you got to investigate that. So that's another key thing to remember. Anytime you get a complaint like that, again, I'm saying it over and over again, it's always a great idea to contact counsel on that. But at the very least, make sure that you investigate. What do you mean? Please tell me what you're talking about. We take those claims very seriously. Document it. If he says, hey, so-and-so, my manager told me, the company doesn't like work comp claims. Okay, go talk to that manager. Did you say that? Things like that. Just, again, make sure you document that thing, because if it ends up in front of a jury, you want to have that on your side. Timing, remember, timing is important too. And courts are all over the place on this, as far as, there's not a set, hey, if you fire somebody within 3 months of having a work comp injury, that is automatic work comp retaliation. It's a sliding scale, and it depends on the circumstances. But as you can imagine, the closer in time you discipline somebody who has a work comp injury, to that injury, the more suspect it's going to be. Meaning, I've had cases where the person reports an injury and they're fired that day. Okay, that might happen. They may have done something to warrant that, but that's going to be really, really suspect to a jury. So just keep that in mind. Whereas on the flip side of that, if it was 8 months before, that's going to be, and there's nothing, the termination was not connected to the injury at all, that's going to be more suspect, for a jury, to the employee. They're going to say, hey, look, this really had nothing to do with it. So just keep that in mind. The closer in time to the injury, the more aware of the situation you want to be. And, again, it does, maybe you have to terminate an employee or discipline an employee really close to the time that they had a workplace injury. I'm not saying you can't do it, but you need to be able to show that there's some kind of intervening factor. Something happened unrelated to the injury or the claim, the work comp claim, that warranted discipline. And hey, we discipline employees for this thing all the time. We discipline employees who have not filed work comp claims or have workplace injuries. If you can show that, hey, we consistently apply this policy, you're going to be in good shape.
So you touched on this real quick, Mitch, but what steps should employers take when they suspect an injury did not occur at work, or an employee is exacerbating a pre-existing condition?
So, and this happens a lot. And again, going back to my, especially when you have particularly like a problem employee, that you may suspect there may be some kind of reason that you believe that, the injury didn't happen at work. It's not an obvious injury. A lot of times what happens is, an employee will come to report an injury maybe a couple days later and say, hey, the other day I was loading this pallet and I pulled my back. And hey, I didn't think about it at the time, but then I went home and I woke up the next morning and it hurt and I thought I'd take some Advil and now it's really hurting me, and so there's not video, there's not witnesses, there's not any objective evidence to say, it's different than if an employee, cuts their hand or whatever. And so when that happens, this is kind of dumb advice, but trust me, just make sure you follow the law. And what I mean by that is make sure that you treat any report of an injury the same. And so if you have if you're self-insured, you're going to want to make sure you follow your policies on that. If you have work comp insurance, it's kind of easy for you because you really just turn that in. And your insurance company, whether they assign counsel or their adjusters review it, they will make that determination whether the injury, occurred at work or not. But you just want to be able to show that if an employee reports an injury, we take it seriously, and we're not, trying to dissuade people from reporting injuries, and that we turn that in. You want to note that employers and employees have certain deadlines in Missouri and Kansas to make those reports. Employers have 5 days from the date of injury or whenever the injury was first reported to them to report it to their insurance carrier. And they have to file a report of injury, and this is in Missouri, by the way. They have to file a report of injury with the Department of Labor within 30 days. Employees also have 30 days from the date of injury to report that to their employer. What happens if an employer doesn't do that? It kind of depends, but the statute, at least in Missouri, says that employers who fail to report can be fined. It even says imprisonment. I've never seen anybody go to prison for this. But what I have seen quite a bit is going back to work comp retaliation. Let's say an employer failed to report the injury timely. That's going to get used in the work comp retaliation claim. And the way that gets used, with the work comp retaliation claim, plaintiffs' attorneys are really trying to spin a narrative to say the company did not want the employee to report the injury for whatever reason, because they don't like these, they're expensive, they don't want their insurance to go up, all these things. And I hear that argument all the time on the plaintiff side, and it's very rare that that's actually true, because most employers are, try to, go above and beyond to say to employees, please report this injury as soon as possible. Let us, it's in our policies, we've got signs posted, we have insurance, and a lot of times, the work comp injuries at issue for a work comp retaliation claim aren't catastrophic injuries. They may be as simple as a strained muscle or whatever. And those are really not going to do much to affect an employer's, work comp rates or anything like that. So, because that's often not the case, you just want to be able to make sure that you can show that. And so again, if an employee reports something, you turn it in. Additionally, if an employee reports an injury and declines medical treatment, you want to make sure that you document that too. They say, hey, I pulled my back. Okay, well, do you need to go to the doctor? No, I'm good right now. Okay, just make sure that they sign something that says that, because again, for example, if you have to discipline them down the road and they claim work comp retaliation and say, hey, yeah, you wouldn't let me go to the doctor. Well, now you have something showing that we offer that to you. Then another thing to be aware of are safety bonuses, or, you kind of seen these posters of so many days without a lost time accident. Courts sometimes don't like those. Now, they're on their face, they're not illegal, but you just want to make sure that you're not, for example, I had a case where an employee claimed work comp retaliation and said, yeah, I didn't initially report my injury because we had gone so many days, we were about to get a bonus, and I didn't want everybody to know that I was the one that caused us not to get that. So just be aware of those. And again, make sure you have those kind of run by your counsel. Couple points on self-insured, or even really if you're not, if you have separate work comp insurance, you do want to make sure you investigate the claim. For all the things we talked about before, if there are witnesses to it, document it. If there's video, save it. Have the employee write out a statement. Those are all going to be things that you need to do. And kind of back to the question of, hey, what if I don't think the employee actually was injured at work? Sometimes I get a situation where they've kind of heard this from another employee. Hey, so-and-so told me that this employee said he fell off his porch this weekend, or he was at the lake and was water skiing, and that's how he was hurt. That's fine. If you get that information, interview it. Don't go looking on Facebook and stuff like that. But you can interview the employee that said that, because a lot of times they don't, employers don't do that at the time. And then, I come in and I want to talk to the employee, and they really kind of backpedal. They're like, oh yeah, he didn't really say that. And, they don't want to be involved. So make sure you talk to them, get their statement, because if that is important information, if there's a reason to think the employee was injured elsewhere, not on the job, that's important information to know for your work comp claim. But you just want to make sure it's documented and not rumors or gossip or things like that.
So Mitch, what happens if we do have an injury on the job, but the employee is not complying with the prescribed medical treatment?
So, and that also happens very frequently. At least with Missouri and Kansas, it's important to remember the employer gets to direct treatment. You can send your employee to whatever treatment provider that you want to, assuming it's reasonable. If they don't want to go to that provider, and they don't have a good reason, like that person's just not qualified or something, they have to get treatment at their own cost. So, make sure that you have treatment providers that you can rely on, and you're going to want to rely on them, as well as, for example, if you are insured, adjusters or third-party administrators that are, and then counsel, because they're going to be working with with the treatment providers, to make sure that the employee is aware of the restrictions. And so, you want to make sure that if you have restrictions, if you send your employee that's injured to, for example, a Concentra, you want to make sure that you're going to get a report that says, the employee can do these things and not do these things. And then he's got a follow-up appointment, at this time. And you want to make sure that if you have light duty, you provide them something that complies with those restrictions. You let them go to their appointments. But if they're not doing it, if they're, for example, not working within their restrictions, even though you've told them to, or if you see them doing something that's different, you can notify your counsel, and then you can send them back to those treatment providers to kind of evaluate what's going on. So you really want to rely on the doctors there, because if this is an issue that, if you've got a work comp claim there, and you've got, counsel, and you want to go to show the administrative law judge, hey, Dr. So-and-so, ordered my employee to do this, and he hasn't done it. You want to make sure you've got medical records that back it up. And if you do, the administrative law judge is going to really scrutinize that employee about why you're not doing that. Like, we've given you, you've been given every opportunity to comply with these. Why haven't you done it? So make sure you rely on those things. Rely on your doctors and kind of notify them, but make sure you're aware of the restrictions and you're following those, and allowing the employee to be able to comply with those.
Yeah. So kind of similar situation, but what happens if the employee is continuing to receive treatment, but they're not showing any signs of improvement?
In kind of the same scenario there, but even though the employer gets to direct treatment, you get to pick where they go. You do have to follow what the doctor says. If the doctor says, hey, I think they're not able to do this, if the employee seems like they are able to do it or whatever, again, you can notify counsel, adjuster, medical provider, to alert the doctor to that. and they can evaluate them for those things. But you want to make sure that you're following their recommendation. But going back to kind of a common injury of, hey, I pulled my back, for example, it's very subjective, right? My back hurts. There's nothing that, necessarily, shows up in a physical exam. You can, again, you want to go through adjusters, counsel, administrators to do this, but you can request ratings from either the treatment provider that's seeing them, or you can get your own independent medical examination from an expert doctor to provide a compensation rating that basically evaluates the person and says, I think, based on everything, I've reviewed all the records for their treatment, I've reviewed how the injury occurred, I've reviewed their job description, and I believe that they are, they'll assign an actual rating based on that. And then that usually kind of sets it up to be able to try to resolve the claim if necessary. Now the employee gets to go get their own rating, that they can do as well. And that kind of, then it becomes the administrative law judge's decision to decide, does he side with the employers or the employees? But yeah, if you've got a situation where, employee is just doesn't seem like anything's working, you rely on the treatment. If the doctor's, typically the doctor is going to call it what's called MMI, or maximum medical improvement. If they're at MMI, they're, it's really kind of set up to give some kind of impairment rating, and that should allow you to be able to close out the claim.
Gotcha. Mitch, could you touch just really briefly on, there's mental health claims on the rise for workers' compensation. So how do those claims differ from a physical workers' compensation claim?
So, yeah, that is a good question. And it's definitely more of a common issue, a more recent common issue. And for example, I had a case where an employee claimed a variety of things. She was terminated for kind of a separate reason, but claimed work comp retaliation and disability discrimination. And she alleged that she developed anxiety because of the way that she was being treated at work. And so for your purpose, again, I'll say it again, contact counsel when you have a situation like this. That's going to be the best course to do it, and make sure managers know to do this as well, or managers know at least to contact HR, upper management, things like that, versus, you don't want a situation where managers just says, oh, that's BS. They're saying they got anxiety because of work, whatever, we all do, right? For your purposes, just make sure you're treating that like any other claim. You're asking those questions, reporting an injury, turning it into your, either talking to counsel or turning it into your insurance, and they will make the determination under the law. Does that meet the standard to be a compensable claim? Now, Missouri and Kansas laws have actually touched on this. Missouri does allow for employees to recover for mental injuries, but there's limitations and requirements. So under statute, mental injuries resulting from work-related stress don't arise out of the course and scope of the employment unless it's demonstrated that the stress is work-related and was extraordinary and unusual. The amount of work stress shall be measured by objective standards and actual events. So it can't just kind of be this vague claim. And then also, a mental injury is not considered to arise out of employment if it resulted from any disciplinary action, work evaluation, job transfer, layoff, demotion, termination, or any similar action taken in good faith by the employer. So again, there are statutory protections to people just kind of making up claims, but for your purposes, even though they've got statutes that kind of give out some guidance, you want to make sure you talk to counsel and they're able to kind of look at the facts, look at the law, and kind of say what happens. Kansas is a little bit more strict. Kansas, psychological injuries must be associated with a physical injury. So like stress, anxiety, depression, or they alone, they're not covered by work comp, but it's got to be connected to the physical injury. So anytime you hear them, just know for managers, if you hear an employee complain of this, make sure you're reporting it like you would any workplace injury.
Sure. Yeah. Seems like mental health work comp claims could be a whole separate topic on its own.
You could, yeah.
Yeah. Well, let's pivot to another poll, which should pop up on your screen again. So please vote. Does your company have a structured return to work program? So send your votes in. They're coming in. And it looks like many of you have built out a pretty structured return to work program, which is great. All right. So thanks everyone for that feedback. We're going to jump over to Aaron now. We're going to get into the nitty-gritty of building an effective return to work program for your injured employees. So Aaron, what does a successful return to work program look like, and what considerations should we as employers think through?
For the question. Thanks, Mitchell, for all that guidance at the front. I really appreciated that. It's really helpful to have these programs in place so we don't have to contact our attorney if necessary. But sometimes having all the right things in place, still those questions can come up. Just on the poll itself, we have 35% said yes, they had a return to work program. 25% said no, leaving 40% unsure. I think if you have 40% unsure, I think that says that the return to work program is not being communicated clearly to the team, or it's unknown to the staff. And I think that's something culturally that can be helped and pushed. Some of that would be around creating good, clear policies and procedures. That is one of the most important things that we can do, is making sure that our employees have a structure, that they understand our commitment to getting them back to their normal work, to their pre-injury state. And then also we want to make sure that that policy is detailing the conditions in which they can resume their regular work. So if you have done any kind of physical evaluations before that have any kind of physical capacity kind of tests that you've done beforehand, obviously those would have to be re-met again before the injured employee would come back. So those would need to be detailed in the policy. We'd want to make sure that it's standardized so that they understand the conditions for rejoining, and that's going to help them want to rejoin more quickly because they understand the process. They know the beginning to the end. As we're doing these programs, we want to make sure we have a program for return to work contact that will coordinate with the employee, because someone's got to communicate with them, so we're continually keeping them updated on what's happening and what the next steps are. When someone feels in the dark, generally they're going to feel like they don't know what they're supposed to do, even if everything was right. The injury was at work. They went to the medical provider. The medical provider gives them their what they're supposed to do to maintain a course of healing, and then they're being prescribed of limitations of work. They following that. Well, if I don't know how I'm supposed to do that, or I don't know what my next steps are, that's going to make that employee feel kind of uneasy, and then there's going to be this concern of like, well, maybe I'm not being taken care of, and so we don't want them to feel like they don't know what's happening, and so we want to make sure someone's coordinating that. We want to make sure that they have some kind of process and the opportunities to do any kind of post-injury work. So we want to have kind of a Rolodex of different types of work that they can do. If you don't have those type of things, sometimes you can find alternatives through nonprofits that you can attach to through your insurance carrier. They have relationships. And so those are really important. But we also want to make sure that we're following through with the medical providers assessment and making sure we're doing exactly what they're asking us to have the employee do, not going beyond that. Even if we give them an alternative work, we want to make sure that it's fitting to the medical provider's requirements and restrictions. And then we want to continue to have a safe work environment. If there was an accident that happened, we want to make sure that we're going backwards. As a safety person, if I don't say this, then clearly I'm not doing my part. But we want to find the root cause of why this employee was injured. If we were to just be lackadaisical about it and say, it just happens, and move forward, I can assume any attorney would look at that and say, well, as an employer, what did you do to make sure this didn't occur again? What steps have you occurred to make sure no other employee's ever been injured in the same capacity? And then why did this even occur in the first place? And so if we don't have the processes and procedures for how to do the work originally in place, this might be a time to really sit down and say, well, why are these procedures not in place around operating that piece of equipment? Can we get that corrected? Do our root cause analysis and do all the things there. And then that also allows them to then flow back into the return to work program to make sure that we can get them back to that work. And then we've corrected any issues we may have found. And hopefully we didn't find that we were at fault and we didn't have any lapse of judgment or anything like that. The last thing is, again, just making sure we have that list of work. Some of that's going to be different depending on the medical restrictions. Sometimes they say, well, can only sit or stand for 40% of their day. Sometimes they have to lay down. And so, if that's the case, be creative in what you have. Sometimes an employee can help, do menial tasks as far as administrative work. Some companies don't have that's available. Some warehousing companies, you do have to do an inventory once a year. Those things can become an opportunity for them to say, hey, I just need you to sit here and count every widget that's in this warehouse in every bin until we get it all accounted for. And those are useful for us because that's a process that has to be done anyway. Sometimes you can have other work where, hey, your job literally is to be here today. You're going to watch so-and-so work. As a safety person for us, maybe we're just going to realign you to being in training today. But again, all that has to fall in line with whatever the medical restrictions are. So,
Erin, you touched on communicating with the injured employee. So how often should an employer communicate with an injured employee?
would encourage early and often. And I think if we're quick to get back to the employee, one that's a value set for anybody. When you feel heard, you're going to feel a value. And when you provide time to somebody, that provides a value set as well. And so, if I was injured and I communicate to my employer that I've been injured and it takes a while for them to get back to me, well, that's a little bit of a concern. Once I've been injured and I've seen the medical doctor and hey, have you heard anything? I've got to call you instead of you call me. That starts to create this antagonistic relationship we're not looking to have. Again, we're trying to help them get back because we want them back as soon as possible. I think we need to look at providing information about this process to our employees on the front side. When we looked at that poll of 40% didn't know that if they had a return to work program. Those right now is an opportunity for every employee to go to their employer, or if you're in charge of these programs at your work, let's get those communicated pieces out and start reminding our employees about a return to work program, reminding them in our meetings and saying, hey, look, we have these systems in place. We want you to be reassured that if something was to happen, we want to make sure that you know that we have processes in place to get you back to work to your full duty as soon as possible. And then whenever an employee's return to work, we want to make sure that we're focusing around just making sure that their time away from work and then monitoring that process is continually just we're being updated on that process as well. So they may have communication from the medical provider. We want to make sure that if any changes are happening, they're communicating that with us as well. And if it feels like it's a balanced approach and we're both working together on this, then everyone kind of feels like this is kind of collectively, moving in a good direction.
Yeah. Clear communication and clear training on our policies and procedures too, for sure. Erin, how can you partner with a medical professional to build the best possible return to work program?
And sometimes you can actually go to those facilities, you can tour those facilities. Some medical providers, you may find that you've been doing this a while and some of them are a varying type. And so you can end up with one doctor that it seems like every time we send an employee there, I just still feel like we're getting not the best outcomes on our return to work. It's okay. You can always, as Mitchell said, especially in Missouri, you can always direct care. Maybe we go ahead and we tour other facilities and we say, hey, this is what we do. This is the type of work we do. And this is how we want to get our employees back to work as soon as possible. And if they understand what we're doing best and they understand our processes, sometimes we can create a relationship with those medical providers that can help create a relationship that's a little more beneficial for everyone involved. Additionally, if we can do open houses, we can sometimes invite some of these people to come to our facility and say, hey, look, this is what we offer. Here's how we do it. That way they have a better understanding of the scope of the work we're doing. Sometimes if it's just like, well, you just do labor work, I don't want you lifting or anything like that. Well, if my labor is, a different type than what they envision, I mean, that creates its own unique thing for everyone. As soon as I say something, we all go to a point in what we think that means. Without any understanding, they can really restrict our employee that maybe doesn't need to be as restricted as much. So,
for sure. Yeah. Thanks for those pointers, Erin. I want to open up to Q&A now. So please send in any questions for the panelists if you've not already. Amanda, what questions have come in already?
Okay, so far we have a couple. The first one is, what should you do when your company does everything for an employee on a workers' comp claim, and then they file a claim through the state as well?
Mitch, that one's probably directed for you.
So, and I guess I want to make sure I understand the question. But because there is, there's obviously a difference between, the employee's injured, you report the injury, and a lot of times that's as far as it goes. You provide the treatment, they get better, they go back to work, end of story. But they do have the right to file an actual claim for compensation where they're saying, hey, I dispute either the treatment I'm getting, I dispute my doctor saying I have to go back to work and I don't think I can, or just, if there's a settlement attempt and they say I'm being offered much less than I should be. So they've got the right to do that. And that's, a lot of times when I see work comp claims, it's at that point, right? They've gotten an attorney. And then, kind of the one step further is what we talked about at the beginning, which is they file a separate civil claim for work comp retaliation. So really, for the first one, if you feel like you do everything that you're supposed to and they still file a claim for compensation, I tell folks folks call me and they're kind of like, hey, how do we do this without getting sued? And I wish I had the magic answer for that. But the reality is we all know that you can be sued for any reason, whether it's valid or not. Now, may not go very far, but you may have this happen. You may have a completely baseless claim for compensation. What you don't want to do is you don't want to turn it into a work comp retaliation claim. So you just want to make sure that, if they have a claim, you are not treating that employee any differently because of that claim. You're letting your either, your adjuster or your counsel, your work comp counsel handle that, the treatment providers, and you're following their directions, you're documenting things, and then you're not taking any kind of adverse action because like I said, even if it's a completely baseless claim for compensation, it can still trigger a work comp retaliation claim.
All right, the next question is, what if an employee keeps complaining about pain, but they aren't going to the doctor because they say they just don't have time? And how does this affect the claim?
So, Aaron, that's you. No, I'm just kidding. So if that happens,
Go right ahead.
Again, you've got the right to direct treatment. If a doctor says they need to do this, they need to show up for an appointment. If they don't, you need to notify the administrative law judge. Kind of going back to what Aaron was talking about with return to work programs. If an employee is injured and for whatever reason they're not able to return to work due to restrictions, or they're not able to return to that specific job, if you don't have any type of job for them, then the employer has to pay them what's called TTD, temporary total disability benefits, which is a portion of their salary, usually up until the point that they can return. But if you are able to provide them some sort of light duty, or I've even seen some employers that are able to do this, charity, like you go and you work for, this nonprofit just to be able to do, maybe it's sitting on a stool and sealing envelopes or something like that, just to be able to, you're preventing from, you have to pay them to do that. But you're at least, giving them, kind of getting them back in the working mindset versus, an employee that maybe thinks I want to sit at home for 3 months and still get, 60 something % of my salary. But if you got an employee that's not following medical, like if he's not going to medical appointments, physical therapy is a big one. A lot of times they'll, because sometimes you have 2 or 3 physical therapy appointments a week. They're not going to it. They're not, you can suspend TTD payments. You can, now administrative law judges are going to want to know the reason. If it's a serious reason, hey, I missed my doctor's appointment because of death in the family or a car wreck, something like that. You have to have a little bit of reasonable grace there. But if it's just, hey, I forgot, or I don't have time, as long as you, the employer, are making time for them to go, you're not saying like you have to be at work, you can't go to your doctor. As long as you're allowing them to do that, they don't really have an excuse. So if they do that, contact your adjuster, your counsel, suspend TTD if it's warranted. And then if it keeps happening, notify the ALJ, because the goal of the work comp system is to, compensate the employee, but allow them to kind of get back into the workforce. And so that's what we're trying to do here is to, follow the treatment provider's instructions, and get that person back working.
You may have just answered this, but a quick follow-up to that. Vanessa said, in this case, they can still do their work. They just aren't going to the doctor, but keeping the claim open and not seeking treatment, but needs it per the doctor.
Yeah. So again, if they're not following treatment, that's a pretty easy one. If you've got, medical records that say they need to be doing this or they need to come to this appointment, they don't do it. Again, that's a question. You go to your adjuster, your counsel, your administrator, because for example, if a employer says that to me, I'm in the employee has an attorney, I'm immediately going to be contacting that attorney and saying, what's going on? We had an appointment, because I mean, we all know doctors, right? Like you will get set for an appointment 30, 60 days out. And, okay, we've been waiting for this appointment. You've had notice, and now they don't show up. And now we have to wait another 30 days to get that person back in. I'm going to want a good reason for why they missed that appointment. And it can't just be, I didn't have time, or I didn't want to go. They've got to, if they want to, have any rights under the work comp system.
Okay, we just had one come in. When an employee is attending the doctor's appointments, are they to receive their hourly or salary pay during that appointment?
Yeah, again, that kind of goes back to, if the employee says, I don't have time to do it, you as the employer need to allow them to be able to do that. And again, it's you're basically treating this as, if they are, again, this is for work injuries. So if totally different than if they fall down the stairs at their house and, it was completely unrelated to work. But if it happened at work, basically that time that they're doing that needs to be treated as work time.
Here's another one. If you question the validity of a claim after seeing video, what would your next steps be? Can a video be forwarded to an adjuster? Any type of consent needed?
No, I mean, if you, now obviously within reason, right? But I mean, yeah, like you have surveillance video in your, for example, warehouse or whatever, loading dock, those are all public areas. A lot of times employers have policies in their handbook that say, hey, we do have surveillance, just FYI, when you're at work, and you're kind of in the open, the floor, whatever, we record those. So yeah, you absolutely want to make sure you're checking those things, because believe it or not, what happens a lot, those, because of data and everything, you don't get a lot of time that those are saved on the system. And so by the time I get it sometimes, I ask the employer, did you have video? Well, yeah, we do, but this was a month ago. So, we don't have it anymore. So you do want to check that. You do want to send those to an adjuster. If it's something, related to it. And then, once it's a claim, this is kind of a point that I didn't get to earlier. And for example, if you think the employer, if you have reason to suspect that the employee is not necessarily doing what they're supposed to, not following restrictions, very often in cases, we'll hire private investigators to go out and do surveillance. A great example of that was a case where an employee fell down the stairs at work, said his back was hurt, took his deposition, said he couldn't even put his socks on, couldn't bend over to put his socks on every morning. We did surveillance. We got him outside of his house. He was working on cars. He literally took the hood off a car, was taking it, moving it around, picking his kids up out of he had a above ground pool, was doing all this stuff. So yeah, you could, if the situation warrants it, that's another option too.
Now, you said this is if the video is company surveillance. What if it's video from like a coworker that submits video? Does that change the need for consent or anything of that nature?
It really depends on what it is, right? I mean, again, if it's a video that one employee takes of another employee out on the production floor, unless you've got a policy against that, which sometimes you do, right? Because maybe you've got something proprietary or whatever, you got to address that. But no, there doesn't necessarily need to be consent there from the employee. Obviously, just no brainer, like bathrooms and in private areas like that, there can't be videos, things like that. But if it's on your premises, and you have regular surveillance, or let's say an employee like takes a picture of another employee on his phone, that's just part of your investigation. So you want to kind of do some due diligence to figure out why that employee has that. Is it legitimate, whatever? But if they say, yes, I actually have this video, look at it. And if it's appropriate, yeah, that can be used. Yeah.
Okay, I have one last question, and Aaron, this one might be for you. Are there cultural issues an employer should consider when building a light duty return to work program?
Sure. There's definitely things that I've heard employers concerned with when you accommodate somebody and they've been on light duty for a while, that other employees might see that as, well, they're not doing the full work, and they're here. And then they feel this creates a negative atmosphere, especially as it starts to create more than one claim popping up around the same time. Now you have 2 or 3 people on light duty, and now you have 2 or 3 gathering around to do light duty work. And then as people are walking by, they see that, and there's employers that have expressed concern around what does that portray to the other employees. And I would say that I hope we frame these things and we communicate these things to all employees, that these are actually us on display, being the good employee, taking care of our employees when they're at a time of need after doing work we've asked them to do and potentially being injured. And so, although that may have a negative connotation or a negative appearance to some, we have to frame those things and represent that as the positive that it is, that we're taking care of our employees. I think that generally, I think that there's the cultural piece to providing light duty is the positive. And I think that creates a well-being approach to our employees, and making sure that they feel valued and well received by the organization, and that what they provide to the organization, that they're going to get in return if something was to, if they were to be hurt by mistake or just by chance, even if it was by their own, mistaken choices, we still want to take care of them, obviously. And so, people make mistakes. That's why we're human beings. And so, that gives us the ability to be human to one another. And I think that speaks volumes to the rest of the employees that, if that's me, then they're going to take care of me too. And that's what we want to have as a resounding message, that as an organization, we're here to take care of all of our employees. So.
Okay, one last question. Hold on, let me find it. Okay, how about accommodating personnel who sustained a personal injury outside of work and would like to return to work?
So in that scenario, if there's no dispute that it was not work related, because sometimes there's kind of situations where an employee goes out, for the job, goes to a site visit or something like that and is injured, is that usually still going to be work related. But if there's no dispute that it happened at home, or whatever, then it becomes a disability ADA type issue. And you just want to make sure if, again, that's kind of where you rely on counsel again. And again, I'm assuming most of you probably have ADA policies that make sure that if there isn't a need for an accommodation, that's been evaluated. You do what's called an interactive process. Sometimes that may require consultation with their doctor who has reviewed their job description to be able to say, this is what they can do, this is what they can't do, and then this is how long they need to be off work. So but yeah, that if there's no dispute that it did not happen at work, it is going to be completely separate from any of the work comp stuff that we've been talking about today.
Okay, we have 2. I'm going to sneak one last question. I think that might be the last time I've said that. Okay, this will have to be the last one. When on light duty, an employee is paid their regular hourly salary rate, not the work comp lesser pay amount. Mitch, this is in the chat. If you want to look at it, it might be easier than listening to me verbally. More specifically, if they are working light duty but less than 40 hours, would it be a combo of their hourly rate and the work comp pay?
Yeah, I think the question is, if they're on light duty, do they get paid their full pay? And in Missouri and Kansas, I believe too, depending on what it is, it's probably going to be, it could be a lesser kind of a temporary total or temporary partial disability payment. And that's again, you're not, unless you're self-insured, with some folks maybe, you're not really going to have to be required to do that calculation. That's where most, third-party work comp administrators kind of have that calculation down. You just want to make sure you're able to report that, hey, we have light duty available. Here's exactly what they're doing. It meets with their restrictions, and then they should be able, either the administrator or your counsel should be able to tell you, this is how much you need to pay them for this time.
Okay. Alrighty. Thank you, Shannon, Aaron, and Mitch. Thank you guys. Thank you everybody for joining us. If you happen to have additional questions, there will be contact information in the follow-up email, which will be sent out tomorrow morning. So thank you everybody for joining us. Have a great afternoon.
Thank you.